these two words. One is, I'm sorry, I thought it was Sri Lanka, it was Madurai, which is great. Let's focus on the second one first. The interesting bit about, you just had a look and you saw what happened in the Supreme Court of Canada in a particular case which had all the trappings. You had a young counsel who was extremely articulate. He was very, very sort of mindful of the time limit and what he said, and every word that he actually spoke is not only video recorded but also it is audio recorded. Okay, and that's the amazing bit. We'll come to that as we speak. But I just wanted to give you a sense of not what we see in our courts today and how a court and this is very normal. This is not something very exceptional. I mean, that little amusing example of if the Chief Justice started a school, things like that. So even there's a lot of sort of interplay with words and jocularism, and which is fine, even in courts abroad. So now let's come to the topic which we're really talking about. Okay, first and foremost, I'll just give you a little bit of a background. As Sucheta said, I went from here completely homegrown as an Indian lawyer, and fine, as standing counsel we like to stand. So that's fine. So in essence, I practice here from starting with the Labour Court and then the High Court and then the Supreme Court in several matters. And then one fine day in 2013 or 14, I was asked to appear for a particular matter in the Supreme Court of British Columbia, which is equivalent to our High Court. We were also called, if you remember, the Supreme Court of Bombay, which is many years ago, before independence. Now, it was very interesting that one went into a courtroom very, very quiet, like how the Supreme Court in India was many years ago, very quiet place, extremely plush. That's another, you think you're entering a 5-star hotel. And then you had the judge. The judges over there wear red gowns, so it's quite, the counsel or the barristers, they wear much thicker sort of gowns and with the upturned collars than we. I mean, they look more like our judges in that sense. They dress up like that. And here I was wearing an Indian coat, Indian band, and Indian gown. And we have some lawyers here, so we know how. And the beauty about our gowns are they were very light. So everybody was asking, where did you get this from? I said, no, I'm from India. So and then the case happened. Now, in this particular case, the applicant or the accused, this was basically where this particular gentleman of Indian origin was accused of an 800-year-old law saying that you had committed contempt of the Supreme Court of British Columbia. And there was no case law that was available at all in Canada. So this guy started looking for lawyers in Canada. He started, unfortunately he couldn't get anybody because they had never done something like that. Then he started looking outside because they follow the common law system. The Queen of England is still the head of their state. So he started going out. So he spoke to Nelson Mandela's lawyer. He spoke to Julius Assange, British solicitor, that is Mr. Mark Stevens. And then he spoke to this little thumb of Tom Thumb, Jamshed Mistry, saying that, can you help me? When I heard Mark Stevens' name, it's like, when you hear, so I said, you mean Mark Stevens will actually be present in court? So he said, yes. I said, fantastic, I'm on.
I didn't know what it was all about, but I said, let's go ahead and do that. Very interestingly, I mean, this is again something very interesting. We were able to do all our research sitting in India. Okay, we have Canadian, just as you have the precedents, the All India reporters, etc. We were able to get all that. I request, if anybody wants to, you have the Bombay High Court website. A lot of international case law is available there. It's a great place to look at. So we did all the research and we sent it to him. If you remember, many years ago, the Contempt of Courts Act in 2005 was actually amended to include truth and public interest as a defense. I remember how difficult it was to get something like that on our statute book. We did it in India. So I said, we have that, the background. So why don't we use that also and show it as comparative law in Canada itself? So when the case actually came on, and what did I notice? So you had the judge, you had the reader or the associate sitting down, you had this gentleman who was appearing on his own, who said, I need the assistance of a counsel from a Commonwealth country, and then you had the Crown or the government counsels on that side. The judge was of Caucasian descent. The associate was Chinese. This gentleman was a Sikh, and the other two. And here I was from Mumbai, India. We argued the matter. It went on for about a couple of hours during the day, and we came out. We stepped out. All was fine. And in the evening, the client comes and gives me something. I'll just show it to you. Sorry, I brought it. Something like this. So he says, I said, what is this? He says, this is the transcript. I said, I see. I said, I have never seen something like this before. Can I have a look? He said, sure. Now, typically, this is the name of the case, the parties. There is an index. It is outsourced to a private body. So the court has actually outsourced it. And then you have the entire proceedings verbatim, including a dash. There's a dash. Everything. So what I have argued, or what happened and transpired in court on 17th of September 2014 at a particular time to a particular time is recorded. Okay. So this is one. What is interesting is, every single, so I said, this is great, this is fantastic, I said, you mean you get this for, every single case? He said, yes. If you are, in certain cases you apply for it. In criminal cases, and if a person is not of sufficient means, it is free of cost, it's given to you, say as legal aid. The same client then said, I am coming to India. I said, come. So he came, he got bail, and he flew with me to India, and I had a matter in the High Court, and he came and he saw what happened, and he said, but where's the transcript? He said, who's this? There was this person who's sitting next to the judge writing something, but how come I don't see the timer, I don't see. So I said, my friend, there is no transcription here. So we were, we were like, diametric, like North and South Pole, and trying to talk to each other about this. I mean, I was quite apologetic to him, saying that, listen, but he said, listen, you're a common law system. Why don't you have transcript? And what do you do? I met over in, for example, in British Columbia, what we call, for example, the Advocate General or the Attorney General, and it was a lady at that point of time. The Attorney General and Law Minister over there is one and the same person. So it's a great thing. So she asked me, she said, we were having a chat, and she said, what can we do to collaborate and things like that. I said, you know what, in India there is no transcription. So she said, what? She said, how do you appeal a judgment? So I said, we appeal the judgment only on the basis of what the judge puts together and says that, well, this is what he thinks is the law. So, there was a complete shock. We said, okay, fair enough. Now, let's go back to 2 years ago. Our senior advocate, Mrs. Indira Jaisingh, they filed this petition, in fact, a couple of petitions on the whole issue about live streaming. I immediately called her up and I said, you know what, I said, this is great. I'm very happy that you filed it. But I said, there is one area that we are missing, and that is legal transcription. I said, suppose if the Supreme Court says no live streaming, then what happens? He said, no, you're right. And that's when I spoke to my school friend actually, Amrish Kilachand, and I said, you know what, I said, you've seen what it is like abroad, etc. Why don't we intervene? So he said, it's a great idea and we should do it. So we intervened in the about 3 or 4 petitions. One of us, the law students, and a couple of others who had filed, and we argued, and we said that yes, we completely support live streaming, but apart from that, if we must have legal transcription and the 3 judges, Chief Justice, Justice Kanvilkar and Justice Chandrachud, not only allowed our applications but said that this must be done. So great. So on the same day that the Aadhaar judgment, September 2018, the courts have now said that yes, transcription is necessary. Now let's go back again in the point of time. I started researching during that period of time. I said, surely if this is a common law or something that has come down from the British, I mean, it must have been there somewhere, sometime. I spoke to a lot of people. For example, Mr. Rajan Jaikar, advocate, who's helped in setting up the museums in the Bombay High Court, and of course earlier in the Supreme Court. I spoke to people like him, I had spoken to others. They said, no, we've not found anything like this. Then out of curiosity, I was researching, I came across a famous Tilak's judgment, Bal Gangadhar Tilak, in 1908. And there was the order was passed by the then Justice Dawar, and lo and behold, after reading the judgment, I think you should read the judgment anyway to see how polite they were, for example. Okay, and then finally, after paragraph number 27 onwards, I found what I was looking for. It was one of those eureka moments. There was transcription. It was transcribed. So if in 1908 we had transcription, what has happened and what have we actually missed in this entire period of time? It is all conjecture, I don't know, but I think probably what may have happened is, because we got rid of the jury system, along with that, and it became more judge based, this very important aspect went out. Then we started looking at other systems. We said, why not look at, because we found that the legislature, for example, also uses it. Everything, they used to use stenographers. They used to change stenographers every 10 to 15 minutes over a period of time. Now with technology, you have the Rajya Sabha, Lok Sabha TVs live. Every sort of proceeding of your assembly and the parliament is recorded verbatim. So surely there is now, we have not only technology, but we have people. One great thing about our systems is, and I have to give it to them, is our stenographers. I'm sure some of you may have actually dealt with them. They're amazing. You even as lawyers, I remember even as a junior lawyer, he would say, okay, you dictate the facts. So you dictated, he would take it all down, all in shorthand, and then what would he do? He would transcribe it. Some of them were so good that he said, okay, I don't even want to know. You tell me, it's a writ of mandamus, no? Okay, fine. The draft would come with writ of mandamus, prayers, this, that. Amazing. I mean, hats off to them. So even they used to start at 20 rupees, and some of the senior stenographers in those days, 50 rupees per page. Oh my God, But so we have this group of people who can actually be trained and in transcription. Now, what does transcription actually entail? So of course, I believe technology is such that you can go straight from speaking here to like a direct printout. That's possible. But in law, like for example medical transcription also, you need a human interface. Now suppose our judge suddenly says, yes, Mr. Radhakrishnan, there's a problem. So he will sit down and ensure that the correct name, the correct pronunciation, everything is done. This then gives, okay, so what is the real benefit of this, of legal transcription? Number one, as you saw over there, everything is crystal clear. You can play it, repeat it as time and time again. You can read this again and again. You know what the lawyer, the judge, the witness, everybody said. So there's no escape for anybody. So it's complete transparency, number one. The second aspect is, okay, quite often the media reports things in the way the journalist understands what has happened in court. Very often you can't even hear. Why journalists, even we as lawyers, we can't hear. I mean, Samir is here. How many times we used to confer that what did he say? I mean, we are not persons with disability, but we still can't hear. That's one. So, internationally, for example, the Supreme Court of UK, okay, not only is the order that is appealed against, of course, it is transcribed. Even the judgment, the day the judgment is pronounced, that is transcribed. And the other important aspect is they come out with a press release saying that this is what we actually mean. They just make it simple for everybody else. The other important aspect, which we have a problem sometimes, the judges don't sit on time. Even that will get resolved because there is a watch and a clock saying that so and so has sat at so and so time. No difficulty at all. Okay. So this has brought, and in today's age with technology available, I mean, let's be honest, as Indians we are everywhere. Google, everything is owned by us. I mean, as at least the technology, the acumen is all ours. Why not something like this? Okay, and it also eases off. I'll give you two examples where I have actually told the judges that why can't we have transcription. One was I was appointed amicus in one was at the Kalagoda, whether to allow Kalagoda or not. And I remember at a very crucial juncture, I had a surgery in I think December 2014 it was, and I just missed that whole 1 week. So, the petitioner's lawyer was saying something, the newspapers were saying something, my junior colleague who was there in court was saying a third thing. Now, who do you believe? The judge must have said something else. Who is going to capture all that? And is it possible? The answer is, at that particular point of time, it was not possible. So I went to court and I said that I think it will be great if we had transcription. They looked at us. Second one was our famous potholes matter. Again, where I was, the honorable judge had written a note in 2013. By the time I was appointed, it was 2016. There was papers this much to the ceiling. Even as an amicus to assist the court, and what would the order sheet say? Matter heard on so and so, stand over to so and so. That's it. So I'm supposed to read all this, and after that, everybody else has been there from the beginning, but I am disadvantaged, and then I have to come and assist the court. So you can imagine, these are a couple of examples. How many times we've seen that court cases for admission are heard again and again and again. Benches change. Why can't we have, so and so say, oh, but that was said before another bench. We don't know, we were not there. Hello? This is, let's be honest. Anywhere in the world, this particular aspect can easily be taken care of. It's systematic. There is no problem. The cost to the court is not going to be that much, and it will completely change. And the other important thing is people will stop shouting in court. People will maintain it, as you saw on that particular, the Canadian court, a very strict timeline. 15 minutes. You should see how, please have a look at other cases also. The barristers there profusely apologize if they're even overshot by a minute. It's amazing. And I think all these, it will just make things, and importantly, you will get all your backlog will get, can be, cleared. There will be complete, because we all say, there is no transparency, there is no, in one easy, resolvable, understandable method, you will be able to see a huge change in the way, not only from the citizen's perspective, but from the lawyer's perspective, and importantly, from the judges and the media. I think all the factions can actually, have a much better and a more easier sort of relationship, and there won't be any problem in that. I will end with just one particular example. We had a particular case where a particular bench, this lawyer was arguing. We had actually intervened. This happened in the Bombay High Court not so long ago, and the judge turns around and says, this is not properly drafted. So he says, okay, allow me to withdraw this particular case. We all understood across the board that he has given him liberty to withdraw the case. And in the evening, which now has become a habit, we try and check the online orders. So very often, and since Samir is here, we used to exchange. Samir, have you got it? If not, send it to me. What the order said was, petition dismissed as withdrawn. All applications dismissed. You sirs and respected madams, you decide, is that correct or is that wrong? We hope legal transcription can change all this. Thank you so much.
Thank you so much, Jamshed, for an excellent presentation. I think now we need to hear the other side, because when we went to court the first time, I'm sure it happened to you, the first shock is that you can't even hear what the judge is saying. let alone what your own lawyers are saying. So may I request you to tell us how you got to this?
Okay, well, thank you for having me here. Normally people always speak, judges speak, lawyers speak, but it's very rare that a litigant will come across and speak about all the problems that he faces. And strangely enough, he is the one who is driving the whole system anyway, right? He's the one who's paying the court fees, he's the one who's paying the counsel fees, he is running the whole establishment, okay? And yet, his voice is not heard at all in all this, right? He's always considered whatever. So, I thought I can address this from a litigant's perspective because I've spent more than 22 years in various courts, from the lowest courts to the Supreme Court, across states. I've done a lot of PILs, I've done a lot of RTI, a lot of litigation with BMC, the police, various departments. And when you spend over 20 years and as a litigant, you attend court and you see what goes on, you start getting a perspective that everything's in complete chaos. Okay, first of all, in our country. I mean, that's the first thing you see. The whole system is chock-a-block. I mean, there is today, it's reached the stage to get a date you have to mention before a judge. Please give me a date. Okay, or there's an urgency or whatever these issues are. So it's come to this situation, and normally we find it very easy to blame the judge. Okay, because he's the fall guy. I mean, he's useless, he's this, he's that, he's whatever, But what we don't realize is that, the judges today are taking home over 100 matters every day. Yeah. He sits from 10:30 to 5:30 in court, okay, going through the previous day's matter. You send him home with 100 matters. He's got to go home, he's got a family, he's got to allocate his time, his resources, whatever. He's up to here with work. Okay. So now what happens is, naturally, he will have to choose out of those 100 cases which ones he's going to hear, which are the top. So he creates his board. Okay, he decides these top 10. So now what does that do? It typically limits it to a normal human reaction. Okay, whoever is the biggest counsels appearing or whichever are the biggest cases on board, I think I'll listen to them. Whoever, big companies, big corporates, people, whatever. And, you have this other concept. So now he's already chock-a-block. He's going to find it impossible to hear so many cases. He gives lawyers 5 minutes, 10 minutes time, in which that person who may come with that many papers, but he has to make his point across to the judge. Okay. Now, there are various dynamics that come into play, okay, in this court system between all the stakeholders. So a litigant comes in when he's got a problem in life. Whatever be the problem, personal, corporate, whatever. When he comes into the system, he's coming into a system where he's entering a lawyer's world, which is where the lawyer is going to be making his fees of this case and whatever else is coming his way, right? So now you've got a little bit of a cross-purpose dynamic because the lawyer doesn't want the case to end, right? Because it's probably determining his fees, and the client wants his justice as soon as possible because he's paying for all this money, he's in trouble and he's got all these issues. So, what typically happens is, in this system today, you file a case, right? You think you're going to go and get a hearing, you're not going to get a hearing, okay? Because if you go there for a certain purpose, the counsel on the other side is equally well trained to thwart all this. He'll ask for time, he'll ask for dates. When he realizes that this is not working, he'll file interim motions to stall litigation, chamber summons, motions, always take 10 years to come up. Okay, so now all the main litigation is gone. Okay, you never hear of final hearing suits today. How many people have you heard, I'm going for a final hearing? You never hear it. Because this whole, by the time the final hearing comes up, most people are already, unfortunately passed on. They're not even around. So they're not there. So what's the point of having this system? Okay, when everywhere you move along, it's just, it doesn't end, right? There is no end. It just continues, and the prayers in your final suit and your motions are the same. So, by the time these things come around, there's complete chaos, right? And now the other problem is continuity, right? So now I file my suit, it's come before Judge X. Judge X gives me 10 minutes, say the arguments continue, right? And the opponent lawyer stands up and he starts arguing on something, and then of course there's not enough time, so the judge says, okay, I'll hear it another time or something or whatever, or they ask time. Now the matter gets knocked off the board. Now knocked off the board is another major problem, because to get it back on the board, back before the judge, when there are 150 cases on his board every day, is another whole mission. Now next time the hearing comes after a few months, okay, if at all, and what happens? The judge has changed, right? So now the other counsel is going to stand out, and you're going to repeat your argument, and he's going to stand up and say, I didn't say that. Right? I didn't say that. Or I said this, not that. Or this. Now, you can't blame the judge. He has no record in front of him to know what's been said before or not. Counsels are changing all the time, right? That's another problem. Today I bring ex-counsel, I realize I need to change, and he comes and says something totally different in court. And the whole litigation goes off on a different tangent. But what is there for mainly is not being addressed, okay? And these are what strategies, lawyers use this all the time, and also the question comes down to, in all this, where is the delivery of justice? Okay. 10 minutes if at all, no continuity. People come with whatever the life's work of papers and whatever, and one-line orders, matters are dismissed, or things, and that's it, and who do you blame? There is the blame. The system itself has become so congested, okay, today, that you can't blame anybody. It's just chaotic. So what is the solution? How do you get past all this, right? Government of India is the largest litigant today. Okay, I would say probably 50% of the litigations are frivolous litigations, okay, if not more. Today, I know the BMC wants to throw me out. I go and file a suit in court, because I know next 20 years they'll be. This is the strategy people use today. They're using the courts to deliver injustice. It's in fact partly other way around, right? Many litigants do that to stop proceedings. I've say someone's taken some money, property, whatever. Someone else says, I move the court today. It suits that person to keep it going for 20 years. That means he is indirectly misusing the court and its system to ensure that I don't get justice, or whoever else. It's not me, whoever the litigants are. So in all this system, right, and what does it come down to? It comes down to that time in court, right, which is the interface between the judge and the lawyer on behalf of the litigant. What is spoken there, okay, many times litigants don't even attend matters, so they don't even know what's going on, okay, and these statements are being changed, everything's being changed. I have seen undertakings being given orally in court, which the next time the court says, oh, no, I didn't give any undertaking, right? So this is the system today. You see the Supreme Court today. The Supreme Court, I don't know how many of you have applications or moved before the Supreme Court. However big your matter is, whatever it is, you get 2 minutes. Okay. In 2 minutes, you have to convince that bench that your case is worthy of hearing ahead. Now, when you've got, by the time you reach the Supreme Court, you've gone through already heavy litigation. You've gone through it from the lower courts, you've got paperwork, you've got judgments, counter judgments, everything. By the time it reaches, you get 2 minutes. So how would there be justice? It's not that there's anything wrong with the judges or anything, it's just that the system is overburdened. You cannot expect them to deliver judgment. When there are 150, 200 matters on the Supreme Court judges' benches, you should see those lists. And top of that, in the beginning, people come to mention matters, and then you have all this going on. So there is just complete chaos. So that judge himself is in a situation he wants to be done. He's firefighting all the time, right? Because he has no choice. So then we come down to the other issues. So India is on this great, we want to become a world superpower and we want to be a great place to invest in. Would people really invest if your system or your judiciary is in this state of affairs? Right. This is being, all lawyers and the institution is being asked this question, because today companies come in, they want justice, they want it fast, because obviously they've got lots at stake, there are lots of things happening around them. People, will this system work? It will not work. They will have to change it. And more importantly, within India there is a huge change coming about within the legal system. Judges, as you saw, the Chennai bench, are asking for this, because even lawyers, judges know that this will make their life much easier. Okay, you've got the Gujarat High Court monitoring the lower courts today, okay, via video. So these systems are coming into place. Everyone is pushing. Delhi High Court is almost, I would say, over 50% digitized. Everything goes into archives. These archives are permanent records, they cannot be changed. Okay, so now I come back to the transcription part. So what was that one thing that I saw that is required? if you needed to change the system completely. I mean, partial changing is not going to help, because again you'll come back to this gridlock. It's like, in the middle of a road you build a bridge thinking, hey, I built a flyover, but it comes back to the end of the road and you're back into the same traffic jam, right? So that won't work. The moment you have transcription, as Jamshed mentioned, the first thing you will bring is transparency, right? There will be transparency in the system. Counsels will be restrained by their choice of words. There will be no more blind and random statements made, because it's all recorded. And it opens up the door to perjury, right? Because if you lie and it's recorded, you've got even more trouble. So the first thing you will do, okay, is you will curtail this problem of lawyers going in all directions. And at the end of the day, the client can see what his lawyer has argued for him, which I think is very important, because at the end of the day, you have to know what his words are. Has he understood what I'm trying to tell him? He's got 50 matters himself, the lawyer. I mean, we blame judges. What about lawyers? All big counsel. Have you seen the amount of files they have? I mean, do you really think he's reading all those files? He's not reading it. It's not. It's not possible for him to read it. It's physically not possible, right? Without reading. No, without reading. Our counsels come to court without reading also. They just. So what happens? It's easy for them. It's their profession. But what about a litigant? This is his life. I mean, he's filing litigations for a certain reason, right? He's not just there. This is not his profession. I can promise you he doesn't want to be here. Okay. But he's here because he has no choice.
He is forced to.
He is forced to go there, right? So, this is another thing that transcription do. It will restrain lawyers. The other thing for litigants, one of the big things transcription will do for litigants is it will remove frivolous litigation. This whole concept of, hey, this guy is acting for I'll file a suit against him, I'll do this, I'll fix him, I'll do all these things, it will all end. Okay, but again, it comes down to everything is being recorded and those records are archived on a daily basis. You cannot change that statement. So if a counsel has said X, he's bound to stick by X, right? So the next day, if new counsels come, new judges come, new whoever comes, that statement continues. What it does is, it makes it very easy for judges. Based on transcripts and the law, he can pass judgments without having to look at even the matter, because what's being argued in front of him is what's important. So, and then you have a case, your suit should be brought down to what I call the notice of motions. You come down, you have that hearing, it's done and over with there and then. There is no further hearings. Your case gets dismissed then. What are the issues? Are you finished it then? Why should it prolong? It's, okay, there are some exceptions in tax, other issues where you may need it, but that should be an exception, not the norm. Today has become the norm. Okay, and then the other problem is this appeal process that we have, which I think is in a way pathetic, because once you cross the lower court, now you're going into the Supreme Court, where you have this 2-minute system, and then see, the Supreme Court was not designed to be an appeal court. The Supreme Court is a court of law to test your constitutional matters, the test of law. But today what's happening? Every one of the guys that test the law goes and appeals in Supreme Court. I lost in the lower court, I went to Supreme Court. So you're putting burdens, and in fact I personally think the Supreme Court should become a lot more strict about this. That look, you come here, we are going to fine you, we are going to deter you, we are going to make you pay if you're coming in to do wrong.
Yes.
Right? Because the litigant also should be held responsible. Why not? At the same time, so all should be held responsible. The whole issue is that every stakeholder, and the way he'll become is through transcription, because now everything is recorded. So, civil litigation is all, okay, what about criminal litigation? Okay, what about under trials in our country? Okay. There are lakhs of people languishing in the jails in India who are not tried. They're just sitting. If you have been to criminal courts, a van will come with 50 people. Okay. These people have lost their human, they've become numbers. Yeah. He comes, he stands, he gives his attendance, and he turns around and goes. Okay, the judge doesn't have the time because there are 50 here, plus there are about 200 applications around him. So what does he do? Attendance is given, they're taken back. So now these guys are languishing. Okay. They're just languishing without being told they're guilty or free, whatever. They're just languishing for years on end. Okay. Transcription will end all this. Because then it will come down to the gist, what is the matter, what is the crime in X amount of days, disposed of, and it's end of the matter. There is nothing ahead of it. Okay. So this is another area where I think transcription is absolutely mandatory in the criminal justice system, because it's in complete chaos today. And you hear this about so many innocent people who are languishing in prisons just because they don't have the money to afford a good lawyer or whatever their problems are, but this is the reality of the situation. The other issue that where transcription will help is, what about differently able people? Are they not entitled to the same justice we are? Should they not know what is being spoken in a court of law if they can't make it there? They should know. They should know each and every other proceedings. So this is where I think for differently able people also, it's a perfect mechanism. Right? People who have vision problems or have hearing problems, you can do so many different things with it. But at least they know today that they have justice. Right? And what is being spoken in court, they're able to interface with and understand and respond to, which today they can't. As he says, you can't even hear what's being said in front. I mean, if we find it so difficult, imagine differently able people how difficult they find it, right? If they have to go into a litigation. They also litigate, I'm sure. So that's another area which would benefit hugely from this transcription that. And transcription is not the beginning and end of all. In my opinion, it will solve probably 80% of the problems, but there are still other fundamental problems which I'll just touch upon to give you an idea of how we can even resolve that, right? So today what happens in a suit is, if I want to thwart a suit or if I want to cause trouble, I find chamber summons. I say, he didn't give me the paper. What paper? That's not relevant. Whether it even exists is not relevant. He's not giving me a paper, I'll do the chamber summons, I just place it for hearing, I've got my time that I wanted, I'm sitting back. And this chamber summons, by the time it gets heard, the main suit, nobody even knows what's going to happen to that, right? So coming back to it, I think this transcription, I lost my train of thought. Yeah, sorry, 80%. So the balance 20% in my opinion will come this way. In England, okay, the system that they follow, so suppose you've got a problem, Mr. X and Y are fighting. So what will happen is, you've already reached a stage where you're exchanging letters by lawyers. Both sides know the lawyers, or if they don't know, they'll soon come to know them. So what they do there is, all the lawyers, they have mailboxes, right? So if I'm filing a suit against another person, my lawyer will put it in the mailbox of that lawyer. So now he's alerted, we exchange correspondence. It goes to, say we go ahead with the suit, right? It goes to a pre-registry stage, which would be probably the registrar, protonotary, whatever. All your what we call tutu meme, he didn't give me this paper, this is missing, that is missing, that. Everything is sorted out in that office of the protonotary and master registry. All these problems, where then the case is prepared for the final hearing. And there is no reason for any more delays. I mean, all the everything is cleared out, right? Once you've cleared it out, the matter is listed on X day. That X day, that judge has 10 to 15 matters max. Okay. On that day, that matter will be heard and an order will be passed unless there is a death in the family or there is something very, very serious. No dates are given, order will be passed on that day, end of story. Case closed and it's over with. This is what I think we need to bring in apart from transcription. If we add this one component where the registry should take care of all these issues which stall litigation unnecessarily, then the judge's life is also limited to just hearing the matter. And if we can get a judge to dispose 10 to 15 matters every day properly hearing, and your frivolous litigation drops, and all the other issues drop because of transparency, of transcription, what you will see is the whole system will clean itself up automatically. All these issues that people say, corruption of judges, corruption of lawyers, corruption of litigants, it all disappears because everything is recorded. What are you going to be? Everything that is said is recorded there. There is no more room given for all these things that happen today, which is all Ram Bharosa. Everything is Ram Bharosa. It's all, there is just nothing. I mean, literally there is no continuity means there is just no justice. How can you have a justice system where everything around you is spinning except the litigant? Right? The judges are spinning, they're changing, the lawyers are spinning, they're changing, the system, but the litigant is standing there only, not knowing what to do. Because he's caught in that system. So, what I would recommend is, all of you people who are litigants and who are also lawyers, you all must start pushing using the Supreme Court judgment for transcription of your cases. as more and more applications come in, the courts will be bound to take steps towards this direction, and they're already ordered to the Supreme Court, so there's no reason why they should not take it. Only problem is, it's still causing uncomfort. Anything new is going to cause, discomfort. So of course the judges also are a little wary, everyone's a little wary, but once they get into it, they will themselves realize that there is nothing better that our country needs than this, because this was, in my opinion, sort of iron out all these issues that we have on a daily basis. So from a litigant's perspective, I thought I'll share some of my experiences and trials that I've had to take and what I think should be done. And one last point is, even for RTI, I think they should start transcription there too. Why not? Because in RTI, again, it's like this only. I've fought in the CIC myself. I've appeared in RTI right up to the CIC myself. Like that only. Everything is based on discriminatory issues. Right? There's nothing about it. So, even in RTI you should get it. If transcription is there in RTI, even that will clean up on its own. Because what the public information officer is saying, if it's recorded there, imagine the change that it will make. He will also be careful with what he's saying and recording, because it's all recorded. This is the whole thing. Once it's all recorded, everything changes, I think. And so, this is what I came here to talk to you all about, and thank you for giving me the chance.
Thank you so much, Mr. Kilachand. I think